just so you know, I got a recording device on here right now, but I delivered a number of messages to you in regard to Moore versus J.B. Hunt as to how the configuration, how the arrangement would be modified if Carl Higbie, former Navy SEAL, was signed on as the head of a posse. So it was understood that it isn't only J.B. Hunt that has the capacity to summons the use of force in regard to the enforcement of an order, which would be the summoning of the collective force of the body politic, but rather it's a matter that there's what would be defined as a contra-predatory vigilante posse, which would be using orders issued from the Institute of St. Michael the Archangel Common Law Tribunal in regard to a matter. So if the collective force of the body politic would ever be summoned to enforce any of the types of orders that were issued in any of the Moore versus J.B. Hunt cases, that there would also be the summoning of a contra-predatory vigilante posse on the other side of the line of the dispute. And my question is, how would that, in the arrangement I just described, what would be the effect on the value, the settlement value in J.B. Hunt's position of the Moore versus J.B. Hunt claims? And what would be the basis, to the extent you would consider be justified and or necessary, or in the interest of your client or yourself, to either identify the basis for the position as to what the value would be, or to refuse to provide that, or decline to provide that information. And this is, I do have a recording device on because I got to show continued progress. Obviously, the second restatement of judgments, finality of judgments versus legitimacy of judgments, there is no legitimacy, and there is no finality to a judgment which possesses no legitimacy. But the point is, it does say in second restatement of judgment, which is second restatement of judgments, I think it's chapter 68 or 71 or 72, that a person has to use adequate means in an ongoing way. There's some burden. A person can't just leave the matter for 50 years and then unless he had just cause at every period of time within the 50 years, he has to continue within his limitations and the limitations of his capacities and his circumstances to try to bring the matter to justice. So that question, I believe I understand it's a rather long question. You can defer or do whatever you're going to do. You can hang up the phone, but I at least am able to post this, that the question was posited, you did answer the phone, and I'm then able to maintain a record that I am doing what I can within limitations of my circumstances to mitigate the damages and get this matter brought to a minimally acceptably moral resolution. I'm done.
If you want me to answer your question while you're recording, I want a copy of the recording.
I will send it to you. I can do that. What's it?
That's fine. You have agreed to give me a copy of the recording.
And
obviously that means that if you don't give me a copy of the recording, you cannot use it for purpose. With regard to your question,
you're coming in broken up. Please, time out. Please repeat the second part of that. I couldn't hear you. Please repeat that because you came in all broken up. I understand. I'm going to, if for whatever reason, what are the consequences of you're not getting it? I've got it on an SD card. I'm going to put it on a USB cable, put it in the computer, put it in a file, and send it to you as an attachment on an email. And I'm also going to post it on the website and give you the URL.
If you did, my petition is you have agreed to give me a copy of the recording.
Yes.
And that for the consequence of not providing the copy of the recording is that you cannot use this for any purposes.
Oh, good enough. I agree. If I don't get a confirmation.
Fine. We've agreed. To the extent that I can answer any part of that question that you asked me, has he in fact signed on?
What?
Has he signed on?
Oh, I'm in the process of negotiating that, so I have.
Well, the question is hypothetical.
No, it's not hypothetical. It's practical because
he hasn't signed on.
No, it's practical because it's not some conjectural.
He has not signed on.
No, because I don't know what the terms and conditions are yet. I have to figure out what is an acceptable, what the dollar value is. I guess in that sense you could.
I have some indication that he's willing to sign on.
What's
it's
that?
Hypothetical, and as you know, I don't answer you. I don't discuss your hypotheticals because most of them don't come to fruition. If you have an indication, if you provide me with some evidence that he is willing to sign on to this thing, your question then becomes, what's it worth to us to keep bad things from happening? And then I can answer you, but until he has signed on to the proposition, it's hypothetical, and I'm not going to discuss it. I don't have an answer for you because it's judge stuff.
Good enough. For the time being, I will. I got to cut this off because I got to keep it short enough that it'll attach on an email. If it doesn't attach on the email, it'll be posted. I got to get a new website because I'm out of space in the old website. As soon as I get the new website up, it'll be posted on the website, and you'll get the URL, and then we can proceed from that on to the next stage in the resolution of this dispute. All right. Goodbye. Thank you. Bye.